Okay, so Steve Carlson should have presenter mode as he's
Right.
pulling up his presentation. Let me just do a quick introduction. So the topic here we have today is cross-border litigation using Europe's Unified Patent Court. Speaking on this subject is Stephen Carlson, who is a partner at the law firm Robbins Kaplan. He's an intellectual property litigator who draws upon national and international experience to assist clients with a wide range of legal disputes, including patent litigation, trade secret matters, and copyright disputes. Armed with a keen understanding of the technology that powers his clients' businesses, Mr. Carlson works closely with technology companies to protect and promote their unique interests. So, Steve, thank you so much for joining us. You can take over.
Thank you very much, David. And can you confirm, are my slides showing all right?
Yes, they are.
Excellent. Okay, we'll take it away. And thank you all for joining. Right, there we go. All right, so the topic today is how to leverage the Unified Patent Court, that's the UPC, in cross-border enforcement cases. And my roots in this, I'm not European. I'm not fluent in German, none of that, but I have written a book. And the genesis of this was when I was a much younger lawyer with much more hair. I had a case, we had a US case humming along. We were doing great in litigation, but ultimately that case was doomed due to issues in the US about double patenting. But before we hit the end of our road in the US, the counterpart case took off in Europe. And we, through the German and actually the Dutch system, we crushed the other side. And when they started locking doors in Rotterdam at the ports, that was game over. And we won big. And it was purely because of the European system. And so when I was at Fish and Richardson and we had a Munich office, I wrote a book with them. They provided the content. The Munich office over there provided the content. And I kind of Americanized it, made it a little more palatable to the American audience. But that was back in 2010. And we did a retread in 2016. And then with the UPC coming out, we've done it again. And I want to give kudos to Alexander Harguth and Constance Schalmoser, who are now at the firm of Bonabri, the new firm they started this year. And they have provided a lot of the guts of this, but I've done the Americanizing bit of it. So I do want to make a shameless plug. Here we are, the book. It's great for stocking stuffers, graduation presents. You know, it's a lot of wisdom in here, and it is a couple $100, but if you've got business where you may be wanting to do a case, an enforcement matter, and you want to talk, we can do a deal because I've got a stack of these things. But it is a nice reference, and it's quite important these days because the UPC really is becoming a big deal. And the trick is to learn to use it. So why? What's the big deal about the UPC, and how does it help in cross-border cases? So there's a lot of advantages to the UPC. Primarily, I want to flag the injunctive relief. You can get preliminary injunctions, you can get permanent injunctions, like you just simply will not get in the United States. And that is such a hammer, and it's such a driver of outcomes that, you know, first and foremost, you really want to think about the UPC because it can drive the final settlement, final outcome with the injunctive relief you're getting in Europe. Also, it's fast. The trials there, you'll get to trial in about 12 months. You know, compare that to the US with, you know, putting aside the PTAB, looking at 2 years, add the PTAB on, you're looking at what, 3.5 or 4 years. It's quite a slog in the US, whereas in Europe, you get to trial in 12 months. A cool feature that I'll talk about at some length is the evidentiary seizures. They call them the saisie contrefaçon. And it's a cool little action where it's a standalone case, and the case is the seizure. So we'll talk about that as a way to jumpstart your enforcement campaign through this evidentiary seizure. Europe's also neat from its complexity. You could have a track of litigation at the UPC, and you have a track of litigation in the national courts, country by country. So you can really cook up a storm in terms of different parallel enforcement cases in Europe. The cost is really low. I'm a little embarrassed when I see the budgets come through from my European colleagues. I'm doing one today. And it's like, wow, it's 10% of what we're asking for in the US. It's really low cost. And so for a lot of clients, that's gonna be a big driver that really advocates going to the UPC. And there's a lot of views in this, a lot of opinions, and a lot of, frankly, data, and I'm more willing to talk offline about this, but there's a lot of belief that the UPC is more claimant friendly. A lot of reasons to believe that too. A lot of it not fit for consumption right here in this webinar, but if we talk offline, there's a lot of reasons why you might think that you're going to odds being you're going to get a better result in the UPC given the structure and the motivations over there. So what this means is you could have this parallel case in Europe that puts a lot of pressure on the target. You may do it in tandem with a US case, with your damages case here in the US. You anchor it in the US, but you've got that driver in Europe to really force a deal. So let's talk about the UPC a bit in terms of the structure of it. What is it? It's Swiss cheese. It's supposed to be the unified patent court. That's the U in the UPC. It's not unified. It's a lot of Europe. It's not all of Europe. The big driver is Germany, France, and the Benelux countries, and Italy. That's where your main enforcement leverage is coming from, is those countries, and they're all in the UPC. The UK, not in the UPC, and they will not be for any time in the foreseeable future. One country we're looking at closely and following the referendum and seeing politically what's happening is Ireland. Ireland can be very attractive because it would be the only country in the UPC that has English as a native language. Elsewhere in Europe, it's happening in German, it's happening in French. It may be in England, but it may be in English, but not by native English speakers. And I think we Americans are going to have a lot of value. We put a lot of value on actually being able to litigate in front of English-speaking judges, native English-speaking judges in Ireland. So we're going to watch closely if Ireland is able to get its nose over the line and get into the UPC, but not yet. They're not there yet. So the basic structure of this is there's a collection of local divisions and then a central division. And the local divisions think of those as basically the district courts, where you take your infringement case to enforce your patents. That's where you go sue for infringement. And they're throughout Europe. There's like 4 in Germany. There's 1 in France, Italy, Belgium. You can go to Portugal if you want. The Baltics have it's called a regional division, which the Baltics have grouped together. Scandinavia, you can go to Slovenia. But really, Germany is where we're seeing a lot of the action. France has a lot of action too. The central division is kind of like the PTAB. That's where you go if you want to invalidate a patent. They call it a revocation action. You go to the central division. Now, they've got 3 seats: Paris, Munich, and Milan. Paris is primarily for electrical inventions. Munich is more of the mechanical, and Milan is more of the bio cases. Now, Paris being electrical, everything's electrical these days. The cars are basically computers. So I'm not sure how they're going to sort that out, but that's the basic division between Paris, Munich, and Milan. And if a party is sued in a local division, the basic rule, there's a crazy exception of this we'll get into, but the basic rule is then the counterclaim for the revocation is done in that same local division court. And so it's a unified proceeding with everything done at once. It's not like the older traditional German litigations where there's a split proceeding between infringement in one court and invalidity in a different court. It's not that. You put everything together in one proceeding. So in terms of a timeline, here's a graph. It's pretty simple, and it's 12 months out to the hearing. There's not much in motion practice. There's no Markman hearing in advance. There's no summary judgments. There's no Alice motions. You basically go straight to the hearing. You may have some preliminary challenge on jurisdiction, but otherwise, other than that, you go straight to the hearing in 12 months. There's no off-ramp. And so from a defendant perspective, it's a little bit terrifying because in 12 months, you're in front of the court and you may get enjoined right then and there. And there is no Markman or SJ proceeding, Alice motion prior to that where you may get off the hook. From an appellate structure, you've got two different courts of first instance. That's how the Europeans say it. They don't say trial court, they say court of first instance. And like I said, there's the local divisions. That's your enforcement courts, or your central division. That's your basically the PTAB. And both those tracks get appealed up to one single court of appeal in Luxembourg. And so that's the unifying driver of this UPC is the single court of appeals. There was a question I saw on the age of a patent. Basically, it's a little complicated. It's not an easy answer, but if the patent's been opted out, then you can't be in the UPC, and you can still opt out your patents now, but there's a sunset period within 7 years. Everybody's supposed to be in the UPC. So it's a little bit complicated on which patents qualify, but we're in a sunset period now for another 6 years before everybody's in the UPC. That's the basic theory with a lot of exceptions. So let's talk about injunctions. It's the driver. And this is not the US. This is very much Europe. And it's a little shocking. Here's an example. Seoul Semiconductor versus e-commerce GmbH. This came out of the Dusseldorf local division just last October. And you would not see this in the United States. It's a permanent injunction entered against an electronics distributor, which enjoined the distribution of mobile phones. So, you know, your iPhone. What was the patent on? The patent was on an LED structure. So just a component of the screen. And, you know, the defendant howled, said, no, you can't enjoin this because the LED structure is just this minimal fraction of the cell phone. Like, how could you enjoin the entire cell phone from being distributed? And that would fly in the US, but it doesn't fly in Europe. And they enjoined it. Not only did the defendant have to stop distributing it, but they had to reach back into the supply chain and recall a bunch of phones that were already in the distribution channel. So it's like, wow, like you don't get this in the United States. And it's a little bit terrifying. And, you know, I kind of wonder, once there's a patent on, you know, some aspect of the blinker for the steering wheel in a car, are they really going to enjoin the sale of BMWs? I mean, I don't know, but for now, that is apparently the rule. And so I wonder if this will get restrained by the political powers, but for right now, this is the kind of relief they're ordering. Here's another example of permanent injunctions. I found this to be very surprising. There was an earlier case prior to the UPC where Philips sued Belkin in the German national court system, and they lost. They lost on infringement. And Belkin counterclaimed, brought this nullity action in the parallel invalidity court, and that was still hung up, that was not unresolved, was still pending. And then after Philips lost in the German national court, then the UPC came online, and they filed a new complaint in the UPC on the very same patent. Like, how can that be? They already lost. Well, the UPC took it up. They said, sure. And actually, they found that Belkin infringed the patent, and they imposed a permanent injunction. Like, wow, how could you win that? The only caveat is there was a carve-out for Germany. Because Philips had lost already in Germany, and the German court found the patent not infringed, there was a carve-out in the permanent injunction for Germany. But beyond Germany, so you're talking France, Italy, Benelux, Portugal, Slovenia, the Baltics, etc., there was an injunction, permanent injunction against Belkin. So your prior losses, you can kind of resurrect them, and the UPC is not shy to diverge from the national rulings. They set their own law, and so you can resurrect a dead case. So preliminary injunctions, another hot topic in the UPC. It's a manageable hurdle. You can win. You know, the United States, it's super hard. There's so many hurdles to winning in the United States, but in Europe, they'll grant these. One of the recent case from last August, this about herbicides, and it's pretty simple standard. Is infringement more likely than not? So that's what they want to look at. Is it more likely than not that there's infringement? And then the validity issue, the court will put the burden very much on the defendant. So the defendant's got the burden. And here they said to the defendant, look, don't barrage me with all these arguments. You got three. Pick three arguments. And the court looked at three arguments and found them unpersuasive. And the one caution flag here is the speed issue. You got to bring these fast. And here the court said 2 months, more than 2 months delay, and you may lose your PI. You got to bring these right away. And so don't delay on bringing your PI request. You know, the United States, we're very concerned about showing irreparable harm. Here, the court said that direct competition was enough. You don't, you know, the whole four-factor test we get bogged down out here in the U.S. It's not over there. In this case, commercial harm was good enough. Direct competition was good enough. Do be aware that there's a requirement for a security bond, although in this case, it didn't require one. So you may have to put up a big bond to get your PI in place, but in this case, there wasn't one. Another PI case, I'll flag this, one of the very earliest cases coming out of the UPC was out of the Munich division, the local division, and it granted a PI in this 10x Genomics case, fairly well-known case. It got flipped. So one piece of news, it was flipped very quickly. It was like 8 months from the initial filing of the complaint and the PI to getting up on appeal to an appellate resolution. So like 8 months from complaint to an appeal appellate decision is quite fast. But they did revoke it. Here, the Court of Appeals reversed the PI from Munich. There is a bit of scuttlebutt with the Munich division being a little too friendly on the plaintiff side, and this may be a way to restrain some of that exuberance out of Munich. But basically, they did reaffirm that the burden on infringement is it more likely than not that there's infringement, and they did find that. But on invalidity, they did reaffirm that it's the defendant's burden to come forward. But here, the appellate court re-evaluated the prior art and found differently that the patent was likely to be found invalid. One piece of this ruling I found very interesting is that Harvard was a plaintiff in this case, but they're a non-practicing entity. And so a question was raised, like, does Harvard have standing as an NPE to be seeking this preliminary injunction? And the answer was yes, come on in. Doors open for NPEs. So now they're in, Harvard was in there with 10x Genomics, the practicing entity, but what I understood from that opinion is that, yeah, NPEs are welcome. Another interesting case is, what does it take to establish jurisdiction in the UPC? And here you had a defendant with no physical presence in Europe. The servers, it was a streaming service. All the servers were outside the UPC territory. And they said, hey, no jurisdiction over us because we're not in the UPC territory. And the court said no. Actually, the appellate court said no. If the goods, the electronic services can be downloaded in the UPC, that's good enough. That's sufficient for jurisdiction. Also, an interesting piece of this is the defendant was complaining, said, look, this is not fair because the defendant, the plaintiff sued us on one day in the national court system on related patents, and then the very next day sued us on other related patents in the UPC. And this is crazy. You can have these two parallel litigation tracks on related patents. And the court said, too bad, so sad. It's no problem there. So you can have, it was complete green light to have this multiplicity of suits against a single target on related patents. Well, let's talk about, I think it's a really cool procedure. It's called the in French, I like French, it's le saisie contrefaçon. It's an evidentiary seizure, and this comes out of France. Prior to the UPC, the French really liked to do these saisie contrefaçons. And Italy would do these, and Belgium would do it. Germany would not. And still to this day, like, Germany doesn't do this. But what it is it's not a discovery mechanism in a lawsuit. It is the lawsuit. You file a lawsuit for a saisie. And it's a seizure action that you can bring as a standalone case. And you apply for the saisie. And then if it's granted, you get a bailiff from the court, and a court-appointed expert will go and do one of these dawn raids. Knock, 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 and they go right in, often accompanied by the police. And they'll go right on in, unannounced often, and then they grab stuff. And the expert then will seize enough material, and they'll write a report based on the seized material, and then that report goes to the court and the council. And that's this kind of action. Now, how do you do it? Well, here's first so that was traditional French saisies, and it got incorporated into the Unified Patent Court Act, the UPCA. And so Article 60 of the UPCA basically lays out these provisions allowing the preservation of evidence and the inspection of premises based on these saisies. So it's very much a UPC provision now that's been brought in from French law. So what's it take to get a saisie? Not much at all. You got to show you own the patent. You got to show the patent's in force and not been opted out. That's a whole conversation we have about opt-outs, but as long as the patent is part of the UPC system and not been opted out of the system, that's what you need. Then you got to say exactly where the seizure is going to happen. This is not a fishing expedition, or this is not US style discovery, all documents related to X. It's not that. You got to be specific. Where are you going to go exactly? What are you going to seize? And then you need to explain to the court why you need this to preserve evidence. Now, that's pretty broad. They'll accept a lot of reasons there. And you got to give some basis to show infringement. Now, not too much basis of infringement, because if you already have infringement in the can, you don't need to say Z. But you need enough evidence to say, hey, I got something here, and I need the next step to complete my infringement proof. And so then this is also kind of neat. You can do it in an ex parte. So you don't inform the other side. You need to go, you don't have to do ex parte, but that's typically what is done as ex parte. And you need to show the court this urgency, the diligence needed, and you can't unreasonably delay. If you've waited 3 months, that's been found to be reasonable. But if you push it beyond that, that might be a problem. A driver to allow the saisies and get it approved is the possibility of the destruction of evidence. So you think the digital data may be erased or hidden. that would justify the ex parte nature to allow you to barge in one of these dawn raids and grab stuff before someone deletes the evidence. Often you may have a trade show in Europe, and that's a very limited time window, and the courts will grant these to go seize stuff ex parte at a trade show. You may have to post a bond, so be aware that you may have to open your checkbook for this. One cool feature is that if the court's disinclined to grant the ex parte relief, you can withdraw. And so the other side will not know about this, at least shouldn't know about it. And that I hear from my European colleagues that this is the norm, that if the court's going to deny this, the other side typically will not know. And that's a nice feature. So on the defense side, if you think you might get exposed to this, you can file what's called a protective brief. And you maybe go into a trade show. I got to see a question. I'll come back to it in a bit. The protective brief will be if you feel you may be exposed to one of these saisies or just a case in general, you can file a protective brief with the court. Say, hey, somebody may be arguing, somebody might be darkening your door to say that my stuff should be seized, but let it be known that the patent's not infringed, the patent's invalid, whatever it may be. You can file a protective brief with the court. And so as a potential defendant, as a potential target of one of these saisies, that's a way to get in front of it. Now, if your protective brief is weak, the court may take that as an admission that you don't have a case, so it better be a good protective brief. But that's a way to defang these saisies. There was a question about, can it be, do you need a European company or can it be a US company? US companies can do this. You need a European patent, obviously, but if you've got a European patent that's enforced in the UPC, that's good. Now, they may require you to post a bond. There's a loser pays system. They call it security. You may need to post security to protect in the eventuality of that you lose. And it's a loser pays system. That bond, that security sits there and would cover that eventual loser pays award. So European companies have an easier time with that, but US companies often get hit with these security requirements. A little more nuts and bolts on these seizure actions. It's pretty cheap, 350 euros for the cost. You don't need to pay for the expert. Court appoints the expert. It's court finds that. You can get these really fast, the same day, or it may take a few weeks. And then the bailiff, they can call the cops. And so one of my co-authors, Constantine, from the book, he did one of these in Milan. He said it was a blast. You show up at dawn, and you got the polizei, and you barge in, you just grab stuff, and it's a rush, and they let you do this, right? The report from the expert is confidential. It may be redacted for sharing purposes. Then I have a question, I don't have an answer to it, but how much can you use that in US proceedings, right? It may be, for Rule 11, I don't know if you can use the actual report because it's confidential, but at least you know the answer. You know that, the pressure is X, you know that the thickness is Y, whatever. You know these data, So it should be good for your Rule 11 basis in the United States. So here's an example of one of them. There's a lot of these examples, but here's one. So the C-Corp case, this Novawell from 2023 out of Paris. For jurisdiction, the court asked, well, what's the jurisdiction basis? The patent's valid. It's still valid. It's not been opted out of the UPC. So if you got a valid patent that's not opted out, that's your ticket in the door. Pretty easy burden there. The case involved undersea electrical products, and the plaintiff learned the defendant was going to launch something just 3 months prior. So based on this launch information, the plaintiff moved for a seizure, and no opposition was filed. I guess it was not ex parte. And so they went, the infringement evidence was some brochures they had, some website photos, and they wanted the seizure to kind of prove it up a little better. It was ex parte because of risk of loss of potential digital data. And kind of the punchline was the court said the applicant has made it plausible that it holds a valid patent and that the defendant is threatening to infringe it in Belgium with its products. That's it. Pretty simple stuff. And then an expert was appointed to write a report. And there was no confidentiality because it was all public stuff being seized at the public symposium. So there's an example. There's a lot of these examples. Interesting question in the UPC is jurisdiction. And there's like a lot of jurisdiction questions in the UPC. But this one I found fascinating. And it shows kind of this turf warfare between the central division and the local divisions. It kind of lurking behind this is it seems that there is a strong desire from each individual judge to fill the docket and get a more full docket going in their courts. And you got some courts are very, very busy, like Munich is bursting at the seams. Other courts are quite slow. Portugal, Slovenia, for example, I think there's very few filings out there. So there is some pressure on the courts to actually justify, what they do, and they need cases. So here's an example I found quite interesting. So Edwards Life Sciences, they do heart valves, and they sued a Indian, more or less a knockoff. I hope Merrill's not in the audience here, but basically an Indian knockoff company. They sued the Indian subsidiary and they sued the German subsidiary in Munich in the local division. That's kind of what you do. You sue in the local division, that's the trial court. So what does Merrill do? They got good lawyers. And what they did is they created brand new from scratch, tabula rasa. They created an Italian subsidiary. And so this Italian subsidiary is hatched, and the brand new Italian subsidiary runs off to Paris, to the central division, which is basically the PTAB. And they figure they're going to get better odds at the PTAB than in Munich. And Edwards, they object, say, this is crazy. You can't do that. We sued you first in Munich. And Merrill says, well, nanny nanny boo boo, you only sued our Indian subsidiary. You only sued our German subsidiary in Munich. You didn't sue our Italian subsidiary, which didn't exist yet. And the Paris court says, yeah, that's right. You didn't sue the Italian subsidiary, and so the Italian subsidiary can come to Paris to the PTAB and advance their revocation case here. And Edwards says, well, that's not fair because now there's two bites at the apple by Merrill and for invalidity. And the Paris court says, no, there need not be two bites at the apple as long as the Munich court puts its pencil down and lets us go first. I'm like, it's just like, that's not how it's supposed to be. But there's a little, turf jealousy, I think, going on in Europe, and they're all kind of fighting for the dockets. That's a perception, that's my opinion, and it's half-baked, but I think it's going on. This does create a defensive strategy to file, create a new subsidiary and file preemptively in the central division. So be aware of this kind of turf war between the different jurisdictions. There's also a whole question of Germany versus France versus Benelux versus Italy versus, Portugal. And cases are going to Germany, like 80% of the cases are going to Germany. People will say there's a lot of wisdom in filing in France, especially depending on the case. They've kind of got their own flavor there. You can get a seizure, for example, in France. You can't get a seizure in Germany. So there's reasons, and it's kind of a fresh look to it in Paris, right? The judges are going to be very even keeled, and if you win there, that's probably a very good stamp of approval that you're going to do well on appeal. So look for the long game to appeal, and the French lawyers will say that the French judges are fantastic and bring the cases there because you get a better shot winning if you go up on appeal. Let's see. So let's come back to the overall strategies now that we've got some nuts and bolts here. You know, from a US perspective, how do we use this? First of all, get patents in Europe. There's just no question about this. This is your biggest bang for your IP buck, is Europe. UPC is becoming a very favorable forum. You want to be able to use it. So get your portfolio in Europe. Now, that's actually a complicated proposition because there's at least 3, actually 4 levels of IP you can get over there. The new flavor of patent is the unitary patent. The unitary patent is something when you're coming through the EPO, you check a box and then your patent will be born as a unitary patent. And that's native environment is the UPC. And so it's just born that way. However, you've got all these other EU patents that have come out of the EPO from 20 years ago now that are eligible to go to the UPC. But you may be aware of this whole opt-out phrase. Became a stampede actually. Prior to the court came online June 1st, 2023. And a lot of wisdom was you don't want to be vulnerable to having your patent preemptively attacked and sent off to basically the PTAB, the Central Division. And if your patent had not been opted out, you were vulnerable to a challenger preemptively hitting you with a revocation action in the Central Division. And the wisdom was you could lose everything in that one fell swoop. So the wisdom was opt out and get your EU patent out of the EPO, out of the UPC system, and wait and see how this all shapes up. And that was overwhelmingly people did that. So there was a stampede to get kind of out of the UPC system with all these opt-outs. Now people want to opt back in to enforce. And there's limits on that. First, you can only do it once, and you cannot do it if there's been any kind of enforcement action on that patent. So if there was some kind of revocation challenge, you can't do it. If there's some kind of nullity action, whatever. There's a lot of ways you may get blocked from coming back in. So a lot of people are now rethinking the wisdom of having opted out. And you may want to get back in before you can't get back in. Now, another level of patents is national level patents. You can go to the German patent office and get a German patent. And that will never come into the UPC. You will only enforce that in the German national courts. There is no risk of that getting hit with one of these revocation actions into the Central Division. So people like that because it insulates, it balkanizes everything and makes sure you've got little landmines all over the map. And then there's also, not on my list here, but there's also utility models, which are wonderful little devices that are kind of like baby patents. Those are only out of Germany, maybe a couple other countries in Europe, but they're a German thing. And those are not part of the UPC system. Those are only German systems. And I think the wisdom is, if you got the money for it, maintain a mix of these different jurisdiction options and flavors of patents in your portfolio. Wait, I missed, yeah. So again, from a cross-border perspective, what can I do on the US side to drive a campaign? This discovery is great. You might not be able to launch in the US because you might not have the proof. You might have real thin allegation, thin evidence, and you might be uncomfortable filing in the U.S. So you could do a saisie, and you could have the gendarmes and the polizei swoop in and grab stuff out of some factory in France and get actual data on the accused product. Now, can you use that in the United States? Well, that's an interesting question. You're going to have some confidentiality restrictions, presumably, but you'll know the answer. And if you know the answer, that's probably good enough for Rule 11. Don't quote me on that. Don't cite me on that in your Rule 11 brief, but it should work. Another strategy is the PIs. To get a preliminary injunction. You're not going to win in the United States unless you're a pharma company and your market share and the price is going to crater. It's very, very hard to win a PI in the U.S. But in the UPC, it seems to be a willingness to do it. And you may have to post a bond, but you may get that PI. And if you win that PI, that really can upset the calculus of the defendant. I know it's only a win in Europe, and you're trying to do a global campaign, but for a company not to be able to sell in Europe and maybe have the doors locked in Rotterdam, where all the goods for Europe come through Rotterdam in the Netherlands, if you win that PI that applies and locks doors in Rotterdam, it's game over. I mean, a lot of companies just cannot simply fold Europe. They have to do a deal with you worldwide. So it's a nice, that's what we used before. It was a great strategy and it worked. And that's kind of why I'm making this talk now, is because exactly that. Cost control. You may not have $10 million burning a hole in your pocket in the US to do a US case. 20 million, right? It's what it may cost these days. But in Europe, you can do this for well under $1 million. They're like well under $1 million. And, it's just streamlined, it's fast, there's no discovery, there's very few motions, there's no markman, there's no expert discovery, there's no, summary judgment, there's none of that. You got to get your proof together. And if you got your proof together, you can just go, right? And get your win there. And that winning in Europe may be enough to drive a global deal. So also a nice way to insulate your patents from the PTAB. And, no one's fully insulated from the PTAB, but if you file in Europe, you're probably at trial in 12 months. And you may get your permanent injunction right on the heels of that trial. And so if you file your case in Europe, well, it may take the defendant a couple months to get their PTAB papers together and get on file. But PTAB is going to take 18 months to get to a final written decision. Meanwhile, you've got your permanent injunction in Europe. And so that's a nice way to drive a global deal and protect your patents from the wrath of the PTAB. And lastly here, it's the ultimate hammers is the permanent injunctions. And it's just hard to get these in the United States with eBay. It's just, you may have it depending on the facts of your case. You got direct competition and a limited number of players and no licensing history and all that. But it's hard, right? And it's very, very costly. But in Europe, I showed you a couple cases that solve some of the case where you're simply not going to get that relief in the US. That was the case on the component, the LED component of the screen of a smartphone. You're not going to win that injunction in the US, but they want it in Europe. And so you want to bake that into your cocktail of the relief you're seeking and have that case in Europe where you might get the permanent injunction. And meanwhile, you have that in tandem with your US case with the big damages component and the big market with the US. But this whole overall cocktail of avenues you're seeking, that can be very powerful to drive a global resolution. And I think, and the one last slide is litigation funders love this stuff. And so if you're looking for funding, it's very attractive from a funder's perspective if you've got this multiplicity of suits where you're going to lead with your European case for a fast driver anchored by your US case with a big damages component. That's what they're looking for. Now, do note that if you're doing a funded case, the European lawyers need to be actually paid, and they're not doing this on contingency. Now, there's some wrinkles around that. There's some creativity, but the basic rule is they can't be doing this on contingency. So for your kind of overall funding structure, you need to take that into account. And with that, that's the show. Happy to take any questions.
Great. Thank you very much, Steve. That was a very interesting presentation, and we all learned a lot from that. So if you have questions, feel free to post them on chat. You can send them to me, David Wanatik, the host. So I see you answered a couple of questions along the way. Let's see if there's anything else. Okay. Maybe not specifically about the UPC, but in Europe, are there corollaries to PTAB at the patent offices in Europe?
Yeah, well, so Germany has its federal patent court, and I'll stop sharing here to get the full screen, maybe if I can figure it out. I can't figure it out. That's all right. So there is the federal patent court in Germany, which is a dedicated court for handling nullity actions. That's their fancy word, is nullity actions. The EPO has their board, the opposition board, where a newly issued patent for 9 months, there's a 9-month window where a newly issued patent can be attacked in the opposition board. And then, so yeah, there's multiple channels. I'm sure France has something kind of like Germany's federal patent court, but yeah, there are these dedicated courts that handle validity challenges.
Okay. And so you presented the UPC as being a body that is of great help to plaintiffs, to patentees. If a plaintiff, a patentee was, sort of threatening to use the UPC to gain leverage in negotiations, what would the defendant say? What would the defendant say, that the UPC is not such a great mechanism that, is biased towards the plaintiff?
I mean, there's limitations, right? So one is discovery. There is no discovery. So if you need discovery, you may get it through that seizure I talked about. But if that's not an option, or that doesn't work, you probably can't prove your case. And so that's a big limitation. Another limitation is posting bonds, especially as a U.S. company. You may need to put up a big security to get the case going, or to anchor a preliminary or even permanent injunction. And if you're in negotiations with a target in the U.S., they may run preemptively to the Central Division. And I haven't seen the stats on that, but kind of the belief is that they will be more accommodating of these revocation cases, and maybe more willing to grant those. Basically, these divisions want to fill their dockets. And if you give the claimants what they want, they keep coming back, and you get a lot more of them. And you're seeing that in Munich right now, where that is a full court. They're jammed. But the Central Division, they may be inclined to invalidate patents because that's what they do. That's like the PTAB, right? So, that is a cautionary flag to getting in negotiations pre-suit with companies about Europe, because you may invite this revocation case in the Central Division.
Okay. Are the bonds that have to be posted at the UPC, are they a function of the value at stake?
Yeah. And then, so there's something called a litigation value, I don't understand, honestly. There is a chapter in the book I helped write about this, but I still don't understand it. Somehow it seems kind of arbitrary that you pick a litigation value, and then that litigation value drives the various court fees, including the security that must be posted. So the more at stake, the higher the court fees and the higher the security.
Okay. And how is it decided which language you have to file in?
Yeah, good. It's a great question because right now there are no courts in the UPC with native English speakers. You may file, the plaintiff may file in, whatever language, maybe in German, in Germany. The defendant, particularly if it's an American company, may protest and say that it should be in English. And these protests are getting traction, and the courts seem to be inclined to go with what the defendant is asking. There's a fair amount of case law on this, and they are tending to go with English if it's a English speaking defendant. They do perceive the prejudice to being hauled in as a defendant into a foreign speaking court where you don't really understand the judges, and so that prejudice is resonating, and they tend to go with English.
Okay. And you may have covered this, maybe I didn't catch it, but do you have similar concern with the UPC as people have about PTAB, where some of the same deciders, some of the same judges are the ones that decide to entertain a petition and decide on the case? You have the same people that make those decisions at the
It is the same, it's the same panel. We'll get it. There's a complexity here where you'll get at most two. I'll probably get this wrong, but you're not gonna get three judges from Germany. You're gonna get a mix. It may be two from the home jurisdiction, and they'll also bring in a judge from out of the country. And so you're gonna get this international mix. You can't really control. I think here's the deal. If you file in one of the German divisions, especially Munich, you're gonna get two judges from that division, and you might even know the name if there's only two judges. You'll get a third judge from elsewhere, but you've got 2 out of 3 you already know. Whereas if you file like Portugal, you'll get the Portuguese judge, but you don't know who the other 2 judges are. So you lose that control over, who's decided the case. So that's the gamesmanship I've heard is kind of being able to know the composition of your panel before you go in.
Mm-hmm. And do these judges typically come from the patent offices, or are they litigators or judges?
Yeah, it's interesting because they wanted it's judges generally, judges or litigators. My understanding, and it may be some professors, and so it's a mixed background, but a lot of them were judges, and they wanted talent at the UPC, so they dangled out very generous salaries. They're like double or triple what a normal judge would make in the national court system. There's some complexities to this, and I'd like to talk offline with people about this because there's some interesting dynamics going on about the compensation scheme, because they couldn't agree to pay these fat salaries for full time for all the judges. So some interesting dynamics about all that, but it's really not fit for the webinar right now. But there's some interesting conversations to be had there.
Okay. Anything you want to say about the appealability of decisions that come out of the UPC?
Yeah, you go up. So the Luxembourg is the Court of Appeals. They're supposed to be the unifying driver of it all. And we're just starting to see the first Court of Appeals decisions. I put 2 of them up today. So you are seeing some of that, but there's a lot going on at the first instance level. And so there's a lot of foment, and we'll see how much of a unifying force we're going to get out of Luxembourg.
Okay. Anyway, I think that exhausts our questions, and that brings us up to time is it? 2 o'clock Eastern. So I think we can take a break now, but I would like to thank Steve Carlson for spending a lot of time and educating us on developments at the UPC. This is a very important session that many of us didn't know much about, but have just heard about. So it was really, very, very useful, and you were the right person to speak to us about this, having written the book and done so much work in the US and Europe. So thank you, Steve.
Thank you, David.
All right, so that brings us to our lunch break. Despite what I said earlier about not taking breaks, we'll take our lunch break now. So let's break for about a half an hour. Maybe we'll try to come back a few minutes before. So instead of coming back at 2:30 Eastern, if you can come back maybe at 2:25. The next session is going to be very interesting, and the gentlemen speaking have a lot to talk about as far as contingency lawyers and litigation finance. So I want to try to carve out a few more minutes for them. So let's re-adjourn at 2:25 Eastern. All right, so have a nice lunch, and we'll see you in about 25 minutes.